So this video is going to take you through what is a lawyer. In the UK we have our legal profession split into two main groups, solicitors and barristers. We're going to have a look at them, their role, their training, their selection, as well as looking at other types of lawyers, which is paralegals and legal executives. So the first question that I want you to have a think about is, what characteristics does a lawyer need to have? So the sorts of things that recruiters and firms of solicitors and barrister chambers are looking for: good communication skills, sound judgment, good people skills, an analytical mind, perseverance. So what I'd like you to do, and this is what I'd like you to do throughout, is read and listen to the information about barristers, highlight the relevant information, and then think about coming up with 2 advantages and 2 disadvantages of the training process. If you've got the booklet, and this is Joseph Chamberlain, people, I'm talking to you, you will be able to read along with me. Please make sure that you are highlighting, underlining, and there'll be a set of questions to complete at the end. So the role of barristers. Barristers practice at the bar and are self-employed, usually work out of a set of chambers. Their main responsibilities is drafting documents, giving legal advice. Solicitors may recommend barristers to clients or may ask the barristers directly for this legal advice. Police and accountants, etc. will ask for their opinions on areas such as tax, and barristers tend to practice in specific areas of law, and they operate on what's known as a cab rank rule, and this states that a barrister can't turn down business if it's in their area of law and they offer it. There are some employed barristers, although most are self-employed, and they work for organisations like the Crown Prosecution Service. In terms of rights of audience, which is advocacy, standing up in court, barristers specialise in this, and they have rights of audience in all courts. There are opportunities for progression. After 10 years they can apply to become what's known as a Queen's Counsel, more on that a little later. Queen's Counsels can demand more money and work on higher profile cases, and lawyers have to apply to become a QC, and as part of the application they have to pay a considerable fee of £2,500, provide a set of references, be interviewed, and then a panel recommend people to the Lord Chancellor. Barristers do specific work in criminal cases, so they act as advocates in the Crown Court and the Magistrates' Court if it's serious. They receive a brief of the case from the solicitor, and they advise the solicitor. And barristers are organised into Inns of Court whilst they're training. These are very much like Hogwarts houses, and each of the Inns of Court is supervised by the Bar Council. If a barrister is self-employed, then they join a set of chambers, and they'll be supervised by the head of that chambers, and they share the secretarial services. So there are 4 Inns of Court, and you can see their logos there at the bottom. So you've got Lincoln's Inn, Inner Temple, Middle Temple, and Gray's Inn. In terms of qualification, there are only 12,000 barristers in England and Wales. In terms of other types of lawyers, that's quite a low number, and they're controlled by the General Counsel of the Bar, and they're members of one of the 4 Inns of Court, as we said a second ago. In terms of qualifying, you start with the academic stage. You either have to complete a qualifying law degree or any other degree combined with a 1-year training in the graduate diploma in law. You then go on to do vocational training, which is a 1-year bar professional training course where they learn to do the job of a barrister, and after this they are called to the bar. You then complete a practical pupillage, which is on-the-job training, which is shadowing for 2 6-month contracts, so 12 months in all, and it's quite a small salary. The first of those 6-month periods you are very much just shadowing a more senior barrister, and in the second 6 months you are doing the job for yourself. And then post-qualification, barristers must engage in continuous professional development. So thinking about the evaluation, one of the key things is financial issues. So it costs £15,000 to do the bar professional training course. It costs £12,000-ish to do the graduate diploma in law if you don't have an undergraduate degree in law, and it costs £27,000 for an undergraduate degree. This is an awful lot of money before you've been able to make any money yourself. So it's a real financial commitment, and it's a gamble. You don't know, A, whether you're going to be successful, or B, whether you're going to like the job. Secondly, legal knowledge. Barristers who don't have a law degree, who do the graduate diploma in law, only spend 1 year studying law. Now, the Ormerod Committee said that they expect that most barristers will have a law degree, but not all of them. And you do have to consider whether this is enough theoretical knowledge to support somebody throughout their career. But the biggest issue is probably oversupply. Between 2014 and 2015, 1,500 people studied the bar professional training course, and they were applying for 422 pupilages. So just over 1,000 people that year would have been unsuccessful. But the next year, the unsuccessful 1,000 people plus a new 1,500 people will apply again for the next set of 500 pupilages. And so it goes on and on and on until you have got tens of thousands of people applying for around 500 jobs. So now you should be able to describe the role of barristers, describe the requirements for qualifying as a barrister, and you could create a diagram to show your answer to this. You should be able to say what personal qualities you think a barrister would need and give some reasons for your answers. And would you consider becoming a barrister, and give reasons for your answers? So you'll need to pause the video here to complete those questions. You should also now be able to complete this diagram on the screen. Joseph Chamberlain people, you've got a copy of this in your booklet, thinking about the order in which things happen with the qualification of barristers. So now we're going to move on and have a look at solicitors. Same idea, you'll need to read and listen carefully, highlight and note down the relevant information, come up with 2 advantages, 2 disadvantages around the training process. So looking at the role of solicitors in private firms to start with, they give legal advice to clients, they draft documents, drafting up things like contracts, wills, divorce papers, and do a lot of the administrative work, writing letters, making phone calls, organising, etc. They can get involved in litigation, which sometimes within a firm will be described as part of the negotiation process in preparing a case. So they might be taking part in negotiating in a divorce case with other solicitors. They do commercial work, registering businesses, companies, contracts, etc. And they can do advocacy for clients in court, although they can only advocate in limited circumstances. Solicitors also get involved in criminal cases, so they attend the accused at the police station, they advise the accused on their options, they can give them legal advice or help them to obtain a barrister, interview witnesses, pass information to a barrister, and can represent as a duty solicitor in the magistrates' court. Solicitors do have to have an additional duty solicitor qualification in order to do police station work. Solicitors tend to be employed by a company, so for example building societies, businesses, as well as things like local authorities and central government and the Crown Prosecution Services. They cater to the needs of employers and could advise employers and represent them in court. Solicitors have a fairly limited rights of audience, which means that they can only speak in the lower courts, the magistrates and the county court. The Courts and Legal Services Act 1990 allowed solicitors to apply for a certificate of advocacy, which allows them to speak in higher courts. And they had to already be an experienced advocate in the courts in which they already had the rights of audience and needed to pass an assessment. This was one of the requirements if a solicitor wants to become a Queen's Counsel as well. So moving on to the qualification of solicitors, there are far more solicitors than there are barristers, around about 100,000 in England and Wales, and they're controlled by the Law Society. Qualification starts off the same, academic qualification, either a qualifying law degree or another degree combined with a 1-year training in the graduate diploma in law. They move on to vocational training, which is a 1-year legal practice examination or legal practice course to learn how to do the job. And then practical training, they must obtain a training contract for at least 2 years with practical experience. This is paid, although not very highly, and they do their own work as well as shadowing more senior colleagues. Post-qualification, must complete a 20-day professional skills course to build on skills, and then undergo continuous professional development. So that's the situation at the moment. There is calls to change the legal practice course and the training contract, but currently this is the way that it works. So an evaluation of solicitors. Again, one of the key issues is, like barristers, there are the financial issues. £12,000 currently to do the legal practice course, £12,000 to do the graduate diploma in law, and £27,000 for an undergraduate degree. So it's an awful lot of money, once again. Slightly cheaper than being a barrister, but when you're up in the 50,000s, a couple of £1,000s here and there doesn't make a massive difference when you're talking about those figures on those scales. So legal knowledge. If you don't have an undergraduate degree in law, you only spend 1 year studying the law. Think about it, your A-level qualification is 2 years, and there can be a lack of specialism, especially with high street solicitors in small firms who do a wide range of work, so they're not necessarily experts in one area. And a key issue is legal aid cuts. So there's the reduction of the availability of public funding, which is squeezing quality, because solicitors and solicitors' firms are needing to do more work in less time. So there's always going to be an inevitable knock-on effect on quality. So you should now be able to create a diagram that looks something like this around the training of solicitors. Joseph Chamberlain people, you've got this in your booklet. And you should be able to answer the following questions. Describe the role and work of a solicitor. Describe the requirements for qualifying as a solicitor. Create your diagram to show your answer. What personal qualities do you think a solicitor would need, giving reasons? Describe the requirements and process for making a complaint against a solicitor. You'll be able to get the information for that one in a moment. And would you consider becoming a solicitor, giving reasons for your answer? So a modern question is around fusion of barristers and solicitors. There's a debate as to whether the work of solicitors and barristers should be kept separate, as they currently are, or fused into one profession like the American model. And this could be a 6-mark question that you could be asked in your exam. So the Courts and Legal Services Act 1990 stated that solicitors with experience could represent clients in higher courts and have the same opportunities of progress as barristers, so becoming Queen's Counsel. And the Access to Justice Act 1990 says that all solicitors have rights of audience but must complete training for this, and barristers can now complete preparation work that was traditionally done by solicitors. And we also have a scheme called Bar Direct 2000. Traditionally, solicitors had to introduce clients to barristers. So the barrister wasn't employed by the client, they were employed by the solicitor. But Bar Direct 2000 meant that clients can go straight to the barrister and engage them directly. So all of these issues make me think, well, if solicitors can stand up in court and barristers can do the preparation work and be engaged by clients directly, what is the point in having 2 separate qualification routes to create 2 separate roles when the roles are becoming more and more similar? Well, the arguments for fusing the 2 professions: it can be cheaper for the client because you're only paying one person, there's less time explaining the case to multiple people, it's easier for the clients as they can understand what's happening more easily, and they've only got one person to ask. They're not getting confused by the passing between the solicitor and the barrister and the back and forth. The training process will change, and all new lawyers will be trained in everything, so they will be very skilled. And it will create one consistent complaint system. More on complaints later. There will be a better client-lawyer relationship, and it can lead to an increase in the number of jobs available, as each lawyer will be spending longer on a case, so each lawyer will have fewer cases. But there are arguments against fusing the professions. The training will have to be longer because there will be more to do. This complaints procedure may be quite complex. It might lead to redundancies, so old school solicitors, old school barristers may not be able to find work anymore. And you're not going to have specialist advocates. Currently, barristers offer a second opinion and can offer quite a different view, and that would go if they were fused together. One person would have a very high workload, so could become stressed and overwhelmed, which could lead to poor performance. There would be the loss of the Inns of Courts and the loss of the cab rank rule, which would also mean a loss of tradition. And by getting rid of the cab rank rule, it would mean that the new lawyers would be able to refuse work if they wanted to. So it could mean that people could find it difficult to obtain representation. And cases could take longer as one person's trying to do everything instead of sharing the responsibility between several people. And this could mean that they take longer and also mean that it wasn't cheaper. So if somebody has been qualified as a barrister or as a solicitor for at least 10 years, and if they're a solicitor with an advocacy qualification, it is possible to apply to become a Queen's Counsel or a QC. This is known as taking the silk, because QCs are entitled to wear really nice silk robes. QCs take the more complex and high profile cases and demand higher fees, and they're also known as seniors because they tend to work with a group of juniors. So the normal barristers are the juniors and the QCs are the seniors. Another type of lawyer that you need to know about are legal executives. So again, listen and read along, take notes, and have a think about why someone might choose to become a legal executive instead of a solicitor or barrister. So there are about 23,000 legal executives working in England and Wales, and legal executives are often described as, not entirely accurately, junior solicitors. Legal executives have developed to fill the need for lawyers with limited but specialised areas of law such as family law, probate and conveyancing. Legal executives are professionals, and their governing body is ILEX, the Institute of Legal Executives. ILEX regulates the academic requirements, the training, qualification and operation of their members. In terms of legal executive qualifications, the entry requirements are 5 GCSEs, and there are people who enter the profession straight from school. Many legal executives today have degrees in A-levels, although this is not a requirement. You can take a 5-year apprenticeship working under the supervision of a solicitor, and whilst you're doing that, complete the Institute of Legal Executive course to gain qualifications. After 5 years, having completed the relevant courses and being aged a minimum of 25, you can apply for full ILEX admission and then go on to qualify as a solicitor. So the legal executive route is a fantastic way to earn whilst you learn. So instead of laying out that £50,000 to go to university, to do your law degree, to do your graduate diploma, to then go on to do your legal practice course, and then to try and secure a training contract, you can be working, learning, practicing your skills and qualify at almost the same point. In years past, the legal executive route was seen as a lesser route, but I can absolutely assure you that that is not the case. So if you're thinking about it, I would strongly suggest you have a look at the legal executive route. And finally, we have to have a look at paralegals. So you can see from the cartoon the way that paralegals are seen in the legal profession. So the lady says, "What's a 9-letter word for indispensable?" And the man replies, "Paralegal." So paralegals usually assist solicitors with their caseloads, and it's a very, very wide term for somebody who is working in the law, doing casework, but aren't necessarily qualified as a solicitor. So they're often referred to as the glue of the legal sector, and they're the largest group of legal professionals. Because it's not a regulated role, we don't have any specific figures, but it far exceeds the numbers of solicitors, barristers, legal executives. There are no qualifications necessary, but often being a paralegal is the step prior to getting a training contract. The starting salary is usually around £12,000, but it's not unusual to have to undertake unpaid work first. And there are now specific qualifications such as diploma in legal practice, which would help you on the way with your paralegal studies. So now we're going to have a look at the regulation and complaints of solicitors and barristers. So the overarching board is the Legal Services Board, and beneath them for solicitors is the Law Society, and the Solicitors Regulatory Authority regulates solicitors. Underneath the Legal Services Board for barristers is the General Counsel of the Bar, and regulations for barristers is done by the Bar Standards Board. Complaints for both solicitors and barristers are heard by the Office for Legal Complaints. So thinking more specifically about regulation of solicitors, as I say, this is done by the Solicitors Regulatory Authority, or the SRA. And their purpose is to protect the public by ensuring that solicitors meet high standards and acting where risks are identified. And the SRA makes sure that solicitors adhere to the principles set out in the SRA Code of Conduct. The SRA has the power to fine solicitors up to £2,000, issue a written reprimand, which is a telling off, close a firm down, and prosecute in the Solicitors Disciplinary Tribunal, which has the power to suspend a solicitor from practice or strike them off the roll of solicitors. So very wide-ranging powers here. Barristers are regulated by the Bar Standards Board, and the purpose is to regulate barristers and their professional practice. They make sure that barristers adhere to the principles set out in the board's Code of Conduct and discipline any breaches of that code. If the matter needs to be referred to the Disciplinary Tribunal, it has the power to fine up to £50,000, issue a written reprimand, make the barrister complete further development training, suspend them for up to 12 months practice, or even disbar the barrister. And the Bar Standards Board is responsible for setting education and training requirements, setting continued training requirements to ensure that their skills are maintained throughout their career, setting standards of conduct for barristers, handling complaints, and taking any other disciplinary action which is required. Complaints against solicitors and barristers can be handled by the Office for Legal Complaints, which was created by the Legal Services Act 2007. This is a completely independent body, independent of any other regulator, and the chairman is a non-lawyer, and the majority of its members must also be non-lawyers. It deals with complaints against all sectors of the legal profession about poor service. And the Office for Legal Complaints also set up the Legal Ombudsman in 2010, which can make decisions about complaints. The Legal Ombudsman has the power to make legal professionals apologise to their clients, put things right if additional work can correct the problem, refund or reduce legal fees, and pay compensation for up to £30,000. The negative with the Legal Ombudsman is that it can be quite tricky to lodge a complaint. There's quite a strict time limit after the issue has happened for you to lodge the complaint, and you must have already exhausted any other complaints procedures, so within the firm, for example, before you can approach the Legal Ombudsman. So the combination of having to exhaust all your other complaints routes and lodging your complaint in time can mean that not everybody is able to complain when they ought to be. The Legal Services Act 2007 allowed for alternative business structures to be created within the legal profession. So before this, solicitors and barristers couldn't work together, and there were restrictions on who could offer legal services. The Legal Services Act 2007 allowed anyone to apply for a licence from the Legal Services Board to set up a law firm. This meant that solicitors and barristers can enter into business with non-lawyers. Critics dub this as Tesco's law, because the idea is that you can pick up legal services with your shopping and the whole system becomes more accessible. Currently, companies such as the Cooperative, AA, Saga, Direct Line and BT all hold these licenses. So it means that there are more people able to offer legal services because of these alternative business structures. But the disadvantage is that the pool of qualified people might be watered down, and it might mean that the head of these organisations might not have a good understanding of the needs of legal services. So now you should be able to explain the regulation and complaints against solicitors, explain the regulation and complaints against barristers, and explain and give an overview of alternative business structures.